Hello, I'm Detective Joshua Toma with the Family Abuse and Stalking Training Team, or the FAST Unit. Today, we will be discussing changes made to the Domestic Violence SOP Section 4-25. This is the third of 4 videos related to the McClendon Settlement Agreement. At the end of this video, you will be required to take a short test. Keep in mind that some of the sections that will be discussed were already in the previous policies and other sections are brand new. The new policy for 425 went into effect in April of 2018. APD SOP 425 Domestic Violence 4-25-2 Policy. The policy establishes deadlines for investigating a domestic violence incident. It provides guidance on conducting investigations, identifying the predominant aggressor, restraining orders, and ensuring the safety of the victim and relating parties. 4-25-3 Definitions. Part B. Household members. Household members are defined by Statute 30-3-11 as of July 1, 2010. Household members are as follows: married couples or divorced couples, current or former boyfriend or girlfriend, parents or co-parent, child in common, mother-in-law or father-in-law, grandparent or grandparent-in-law, and continuing personal relationship. Non-household members are as follows: brother, sister, aunt, uncle, cousin, niece, nephew, current or former sibling-in-law, current or former step-grandparent, current or former brother or sister-in-law, and minor or adult children. Subsection C, predominant aggressor. The person determined to be the most significant rather than the first aggressor, and identifying the predominant aggressor, the officer shall consider the intent of the law to protect victims of domestic violence between the persons involved and whether either person acted in self-defense. Emergency restraining order is issued after normal court hours when they are closed, when the facts are sworn to by a sworn law enforcement officer to a district court judge, which can be done telephonically. An ERO is only good for 72 hours or until the next day the courts are open to account for holidays, etc., whichever is longer, and only approved when the respondent's or offender's location is known so they can be served. Temporary restraining order, or TRO, may be issued in response to a petition filed in domestic violence court alleging acts of domestic violence against the petitioner. The petition is reviewed by a DV commissioner and, if approved, is countersigned by a district court judge. Because the process is ex parte, a hearing is scheduled, usually within 2 weeks, at which time both parties, petitioner and respondent, may present evidence to the court. The TRO is not considered active until the respondent has been personally served. Order of protection. If the commissioner hearing the facts finds that an act of domestic violence have occurred, the TRO may be extended for a period of time decided by the commissioner, usually 1 to 2 years, and is now considered an order of protection, or OP, losing the temporary. These are also referred to in the vernacular as restraining orders. The language and definitions has not changed. It was previously approved in 2017 and is still current policy. 4-25-3, Rules and Procedures, Part A2, determining whether to issue a summons or effect an arrest. As stated in the Warrantless Act, Section 31-1-7 of NMSA 1978, officers may arrest a person without a warrant when the officer is at the scene of a domestic disturbance and has probable cause to believe that that person has committed an assault or battery upon a household member. The important change in this policy is shall arrest has been changed to may arrest. 4-25-3A 2B. An officer shall issue a summons if there is probable cause. On-site arrest is not always required. However, officers shall arrest the alleged offender where it has been determined arrest is reasonably necessary to protect the victim from further domestic abuse, or when exigent circumstances necessitate an arrest. If issuing a summons or effecting an arrest, it is incumbent upon the officers at the scene of a domestic violence incident to determine the predominant aggressor. Dual arrest shall not be made for domestic violence offenses. Summonses cannot be issued for both parties arising out of the same incident. A predominant aggressor must be identified. When dealing with persons who may be affected by a behavioral health disorder or behavioral health crisis, officers shall refer to SOP 2-19, Response to Behavioral Health Issues, in particular 2-19-8, regarding diversion from jail when appropriate. 4-25-3A3, Criminal Complaints. If an offender is still at or near the scene of a domestic violence case, the officer shall, when arrest is reasonably necessary to protect the victim from further domestic abuse, make every reasonable attempt to place the offender under arrest, rather than merely issuing a criminal summons, where there is probable cause to believe that the person has committed assault or battery upon a household member. The language in criminal complaints has not been changed. Remember, in all cases, the protection of the victim is the most important consideration. However, the arrest is not mandatory because other methods of protecting the victims from further domestic abuse can be used to protect the victim, where there is probable cause to believe that the person has committed an assault or a battery upon a household member, and whenever exigent circumstances exist, which includes when other actions will not protect the victim from further domestic abuse, an arrest may be made. When arrest is reasonably necessary to protect the victim from further domestic abuse, make every reasonable attempt to place the offender under arrest, rather than merely issuing a criminal summons. Remember, the protection of the victim is very important. 4-25-3A4. Encountering and assisting individuals with behavioral health issues on a domestic violence call. SOP 2-19. Response to behavioral health issues applies to investigations and responses in cases involving domestic violence or abuse. The steps outlined below are not intended to supersede the provisions of SOP 2-19, and in the event of any inconsistency, the provisions of SOP 2-19's control. All officers who respond to domestic disturbance calls must familiarize themselves with SOP 2-19, Response to Behavioral Health Issues. If an officer is called to a domestic disturbance and is informed by dispatch or discovers through investigation that the individual whose behavior, criminal or otherwise, appears to stem from a behavioral health disorder, the officer shall immediate call for assistance from an Enhanced Crisis Intervention Team officer or CIT officer, and if the situation is determined to be a crisis, request a mobile crisis team member. This is new to the policy. Remember, if you are advised by dispatch or other information that the cause of the behavior is a mental health related issue, call for ECIT. If the subject is in crisis, then request the Mobile Crisis Team or MCT. This does not preclude safety on the scene, and officers are reminded to prioritize the security of the scene for all of those involved. While waiting for ECIT officer, MCT, or supervisor to arrive, officers shall de-escalate and calm the situation as much as possible. See SOP 2-19-7. If an MCT is not available and the officer believes the individual to be a danger to themselves or others, the officer may transport the individual to UNMH or another available mental health evaluation facility. See SOP 219-8 and NMSA 43-1-10. So if MCT is unavailable, officers may transport to a mental health facility and are not required to wait for MCT. Officers shall reasonably accommodate the disabilities of an individual who either has a behavioral health disorder or is perceived to have a behavioral health disorder. While doing this, officers shall not sacrifice officer safety. Officers shall not transport an individual whose behavior, criminal or otherwise, appears to stem from a behavioral health disorder to MDC or PTC solely for the purpose of getting mental health treatment for the person. Mental health evaluation and treatment facilities may be used for that purpose. Booking a subject solely for mental health evaluation is not within this policy. An arrest or charge is not necessary to transport the individual to UNMH or other mental health treatment or evaluation facility if the individual who has or appears to have a behavioral health disorder or who is experiencing a behavioral health crisis presents a likelihood of serious harm to himself, herself, or others, including danger to himself, herself, due to grave passive neglect, and that immediate detention is necessary to prevent such harm. If an individual's apparent criminal behavior appears to stem from a behavioral health disorder, and he or she would be better served at a treatment location rather than in a criminal justice setting, officers should seek such interventions in lieu of arrest or criminal charges. See SOP 2-19-8, subsection C. Officers shall not arrest individuals who have or appear to have behavioral health issues solely because they are resisting the assistance of their friends, family members, caregivers, or officers, unless exigent circumstances are present and transporting the individual to a treatment location would be inappropriate. To clarify this change in policy, if an assault or battery has not occurred and the victim's safety is not compromised, jail diversion procedures such as hospitalization, can be instituted. An example of an incident might be the criminal damage or deprivation of property where an offender does not demonstrate violent behavior towards the victim, and the mental health issues are the overriding cause of the dispute. In that instance, a mental health evaluation would be applicable, and summons for the damage could be completed. It is also not necessary to have a chargeable offense to arrange for hospitalization. 4-25-3G, Enforcement of Orders of Protection. This is from the previous policy and is still the current policy. Part 1. When an order of protection is presented to an officer by the complainant, the officer shall: A. Officers will deem if the order is valid using the below noted criteria. B. Determine if the conduct is prohibited by the order. C. Attempt to confirm the order through BCSO Warrant Division or NCIC. D. If it is determined the restrained party has not been served or they are unable to confirm the service, the officer shall serve the restrained party with a copy of the restraining order and file a return of service through BCSO warrants. If the officer has probable cause to believe that the order of protection has been violated, he may arrest the restrained party for the violation of the order, but only when an arrest is reasonably necessary to protect the protected party from further domestic abuse. F. If the officer has probable cause to believe that the order of protection has been violated, the officer shall charge a violation of an order of protection. Officers shall, upon request of the victim, assist in placing the victim in possession of the dwelling or premises, or otherwise assist in execution or service of an order of protection. H. Officers shall enforce the provisions of custody as outlined in the court order of protection that directs removing a child or children from the non-custodial parent or guardian. Subsection 2. Orders of protection must be enforced per NMSA 40-13-6D. Service of order. A peace officer may arrest without a warrant and take into custody a person whom the peace officer had probable cause to believe has violated order under this section. Social support for victims. Upon the request of the victim, the officer shall provide or make reasonable efforts to arrange for transportation to a shelter, safe refuge, or medical facility for victims of domestic abuse. When it is possible, the Sheriff's Department is available. Arrangements can be made for transportation to destinations substantially outside the city limits, but within Bernalillo County. A reasonable effort to resolve the situation locally is sufficient until other arrangements can be made at a more appropriate time. Police service aids should be utilized whenever possible or practical. However, it is the officer's responsibility to make sure that the mandate of the court is carried out. Officers will give victims a domestic violence packet. Also, victim advocates can be utilized through numerous domestic violence assistance agencies, such as the Family Advocacy Center. Advocates can not only assist victims with filling out and filing orders of protection, but they can provide many different resources to the victims. There are also who would call for assistance in the emergency restraining order process. Victim advocates are available 24 hours a day, and they do accept walk-ins at the FAC from 8 to 5, Monday through Friday. Thank you for your time. If you have any questions, feel free to contact the FAST unit at 924-6000.